Good morning or good afternoon, depending on where you are at. Welcome to today's webinar from Spark TS, our FMCSA Clearinghouse II, understanding the November deadline. But hey, we got some other things outside of the clearinghouse we're going to talk to you about today. But just as a reminder who we are, Spark TS, we are a TPA, a third-party administrator with a full-service lab and MRO. We do have random pool management with a consortium, and we assist with policy and compliance development. We have 24/7 on-site testing with clinic services where you can order electronic chain of custodies 24 hours a day. And we have our Rail Tasker and People Tasker software, our software solution that's designed for the DER to support drug and alcohol program management. But enough about that. We have a very exciting person with us today. Oh, I forgot to talk about us. Our leadership team, Katie, anyway, is our CEO and founder. And I, Holly Rainwater, am the Vice President of Drug and Alcohol. I myself have over 20 years of industry experience managing drug and alcohol testing programs. Katie has experience in 243 software compliance for railroads and training. With that being said, now we'll actually get to our speakers today. Today, I'm very excited to have Charles St. Martin with us. Charles is a federal program specialist with the Federal Motor Carrier Safety Administration. And I'm just going to be in the background asking questions. I'm Holly Rainwater, and I am the Vice President of Drug and Alcohol Programs here at Spark TS. Today, we're really excited. I'm going to make Charles the presenter now and go over to Charles. And it's really great to have Charles on. I met with him a couple times, and his knowledge of the regulation under FMCSA is just really valuable. And maybe Charles will tell us even about the detail he recently worked on, which I thought was really neat, and the opportunities. But if you've got questions during today's session, please feel free to put them in the chat so we can answer them. If I know we have a few questions that came in prior, we'll get to those as well. Charles, I'm sure they've heard enough of me. I'd like to kick it over to you.
Okay, thanks, Holly. I haven't been called Charles this many times since my mom passed away, because that's what she called me when I was in trouble. I'm a little bit scared right now. Okay, so my name is
trouble yet.
My name is Chuck St. Martin. I'm the Federal Program Specialist with the Minnesota Division of FMCSA. I know you guys are familiar with FMCSA, so I won't bore you a whole lot with it. I also don't want to bore you a lot with me. I've been around essentially forever, decades, as an investigator, program manager. I was the head of the drug tag for FMCSA. I did a detail with the Office of Drug and Alcohol Policy and Compliance. That's enough. That's enough about me. Once I get started here, I'm going to flip the camera off because this particular shirt is very distracting. I used to say that my good looks were, but that ship has sailed. All right, that being said, I'm going to flip the camera off right now. And you guys, I assume, can still see the presentation? Good to go?
Yes.
Okay.
You're good.
All right. The initial ask from Holly was, hey, we know something's happening coming up in November, and it has to do with the clearinghouse and CDLs. That's how this conversation started. That is one of the topics we're going to talk about. But the more we talked, the more topics came up about, hey, could you talk about that? Could you talk about that? Essentially, we're going to do 3 chunks. The first chunk is a really quick one. It's going to be random testing and multi-modal operations. I know the bulk of you, I believe the bulk of you are Rail/FMCSA. This may be a little helpful there. Hopefully, it's just a couple of quick screens just to explain where on the FMCSA side of things, which is the only thing I can really talk about, the way you should be handling the random pool for those modal situations. Then we're going to do an overview of the Drug and Alcohol Clearinghouse, which again is an FMCSA only clearinghouse. That's one of the questions we get asked pretty regularly on these types of calls is, hey, if somebody tests positive on a federal rail or an FAA or whatever, on one of those regulated tests, does that go in the clearinghouse? It does not. You're falling back to your old, what the FMCSA people call the old days, which is when you have to actually do your required requests from the previous employer, that sort of thing. The clearinghouse is only FMCSA violations. Then the last thing we're going to talk about is exactly how I started this conversation. We're going to give you a nutshell, really, of what's happening on November 18th and how it's going to affect potentially your operations. That being said, let's go. I do believe that we will have some time at the end for as many questions as you want. I can stick around for a bit if you like. The first topic is random testing and multimodal operations. There's really only two slides here. So the first one, and again, these 382, 305, that's our FMCSRs. That's our regulations for federal motor carrier. If you have a driver, just a driver, who's subject to drug testing both for FMCSA and the second mode, which again, I understand is rail for this group for the most part. The driver shall be subject to random alcohol testing and drug testing at the annual percentage rate established for the calendar year by the DOT agency regulating more than 50% of the driver's function. That's really your question. Okay, I got Bob who does both. What does he spend more time doing? If he spends more time on the federal rail side, that's the random pool that they belong in. That's when you do your chain of custody, that's the box you're going to be checking. Okay. The second part of this, which is sequential in our regulations, is 32305O. And what this is, if you have an employer that has regulated employees for more than one DOT agency, there's two ways to do this. One is you can establish separate pools, which each pool containing the DOT covered for whichever mode they're subject to. Or you can do the second, which is you can have them all in one pool, but you have to make sure that pool is testing at the highest minimum annual percentage rate. If you have two different pools, say one of them is the required rate is 50%, the other is 25. If you're doing one pool, you have to test at the 50. You can see how some employers for the lower percentage mode may not be fond of that because they're probably going to get tested more than they're really required to, but the option is there. Those are the two simplistic situations we have with multimodal drivers within an employer, and then multimodal, the entire business basically being multimodal. All right, let's talk about the clearinghouse. For those of you that are FMCSA regulated in the room and have not registered for the clearinghouse, or maybe you registered in 2020, but you haven't really done anything since, you're not alone, but we need to get this thing started. I'm going to give you a walkthrough on the history of it, why we have it, how it works. It's going to be pretty basic. But the main message here is if you're already doing the clearinghouse and you're doing all your queries and reports, fantastic. But if you're not, now is the time. And I think I'll give you a couple good reasons here at the end, other than being in regulatory noncompliance, which is never a good thing. Okay, so here's the background of the clearinghouse. Back, maybe 10, 15 years ago, I had always heard these rumors that there were potentially thousands, maybe even 10,000 drivers who were prohibited because at some point on the DOT test they had positive, or maybe they refused, or maybe one of the other prohibitions, but they were still out driving. Now keep in mind, and I'm an FMCSA guy, I'm going to keep talking about driving. You guys know what your safety sensitive functions are. But I thought that number was a little crazy, but I knew anecdotally it was happening because we were running across them during our compliance reviews. Congress found out about this too. And way back in 2012, there was a FMCSA reauthorization, it was a DOT reauthorization called MAP 21 that covered a whole bunch of different things. But one of the main ones was that, hey, FMCSA, you need to create clearinghouse that these drivers don't disappear into the wind, which is exactly what they were doing. The final rule was published in 2016, which established all the requirements for the clearinghouse, and it was implemented on January 6, 2020. Do the math there. That was almost 8 years. We work at the speed of government here, but at least it's implemented, and I'm telling you, it may not be perfect, but it's really good, and it's serving the exact function that we need it to. That being said, I want to give you guys a basic concept of what's going on here. What is an overview of it? The employers have two primary roles. Reporting certain violations, which we'll talk about in a little bit. The most common violation is a positive test, right? That being the case, the MRO is actually reporting that. Employers do not have to report MRO verified positive results. The types of violations employers would have to report are things like if they had an breath alcohol, or excuse me, that's redundant, a breath alcohol test over 0.04 or higher, if they have a refusal situation, because neither of those situations does any paperwork go to the MRO. The MRO is not going to know about it. The employer actually needs to enter those violations into the clearinghouse. The second bullet here, which is querying the clearinghouse right up here, is 99% of the work that employers are going to be doing inside the clearinghouse. With any luck at all, you won't have to report any violations, but you are required to query the clearinghouse. And there's two different types of queries. When you first hire a CDL required driver, or a driver that's going to be operating a CDL vehicle, you need to do a pre-employment query. It's what we call a full query. What that means is the driver needs to register, and they need to provide electronic consent to the employer. So you're going into your clearinghouse account saying, hey, I'm hiring Chuck. I'm going to send a request to Chuck electronically. I need to set up an account if I haven't already, and I'm just going to hit the little green button in there that says, I accept your request. The moment I hit that green button, you as the employer are going to have access to my clearinghouse account. Hopefully, what that's telling you is that I'm not prohibited. Because if that's the case, you don't need to worry about the other headaches that go with potentially hiring a prohibited driver. And you can certainly hire the prohibited driver. There's plenty of great drivers out there that have made mistakes, but you'd have to follow the return to duty process and the follow-up testing. The second is called an annual query. Excuse me. The annual query is just like it sounds, once a year, at least once a year. You can run it as many times as you want, but quite honestly, there really isn't any point anymore to doing it more than once a year, and I'll explain that in a second. The limited query does not require the driver to have electronic consent. This is basically when you hire this person, there's a piece of paper that you're dropping in front of them, and they're going to be signing it. And all it says is, I am providing my written authorization to this employer to run my limited query. You can do it a couple of different ways. What most people do is they just change the wording in there. It says for the duration of their employment, so that you don't have to sign this thing every year, right? But if you haven't done that already, it's a good idea just to change the wording in that piece of paper saying, I, Chuck St. Martin, provide consent to ABC Trucking to run limited queries for the duration of my employment. That's the basic concepts. And keep in mind, the most important part here is what we're really looking for is we're querying to see if these drivers are prohibited. And by prohibited, that means that there was a violation entered into the clearinghouse that has not been cleared up yet. And by cleared up, I'm talking about there hasn't been a return to duty negative entered. Just to back up a little bit there. You're required to use the clearinghouse. There are really 6 different categories here. Obviously, drivers who hold CDLs, or at least who operate CDL vehicles. They're the whole reason for the clearinghouse. The second is the employers of those drivers. And I just explained essentially what that means is they need to go in pre-employment and make sure they're not prohibited, and they're going to run an annual. When you run an annual or a pre-employment, the clearinghouse now has some functionality that just got added a few months back, where it's a 365-day look-back period. And what that means is if I'm your employee and you run either a limited or a full, it doesn't matter, pre-employment or limited, query on me, if anything is entered into my clearinghouse account for the next 365 days, you're going to get notified. The notification is just going to say, hey, something's going on with Chuck's clearinghouse account. You then need to go in. At that point, you do need to have my electronic consent to look. If I don't provide the electronic consent, you can no longer use me. Okay. A lot of times what's going on in there, doesn't mean there's a new violation there. It might be a return to duty test was entered, or there's some other things that could be going on in there. The consortium, third-party administrators, everything that the employer does, not only in drug and alcohol testing, but also within the clearinghouse, they can hire somebody to do it for them. And that's what this group is, the consortium. If an employer says, hey, I want to use whoever as my third-party administrator within the clearinghouse, they can select, I want them to do my reporting, or I want them to do my queries, or both. It's just a matter of them hooking up in the clearinghouse, which there's a process for that. But once they are hooked up in the clearinghouse, the third-party administrator can do all of the work for the employer. Medical review officers obviously need access to the clearinghouse because those are the folks that are entering the positive test into the clearinghouse. Substance abuse professionals need to be in there as well because if you have a driver that's prohibited, they're running through the SAP process, the duty process. There are certain reporting requirements that SAP needs to enter into the clearinghouse. They obviously have to have access to the clearinghouse as well. And then the last thing here was the state driver's license agencies, which we're going to talk about at the end here. November of 2024 is creeping up in a hurry. And a little bit of the backstory here is the original rule, which I explained, talked about the state driver's license agencies being required to take action on licenses, CDLs, for those folks that are prohibited in the clearinghouse. The problem was the rule was written, let's just say vaguely, and the state driver's license agency said, this isn't clear enough for us. You're not telling us exactly what we need to do. There was a second clearinghouse rule written, which is what this November 2024 date is all about. And again, we'll talk about what they actually have to do right at the end of this presentation. Drivers, what do the drivers need to do in the clearinghouse? They need to register, which is really not completely true because there are some drivers that may never have to register. From January of 2020 until the time they retire, if they never have a new employer and they never have a violation, they never have to register. The only time a driver really needs to register is if they go from one employer to the next because they have to have that electronic consent in the clearinghouse to run the query, the pre-employment query. That's one reason. The other is if they have a violation reported against them and they want to go through the return to duty process. We get the question a lot. Is there a requirement for drivers to register? Not really. However, if you want a new job, or you need to report all your return to duty, then you're going to have to register. And I have some numbers here in a little bit that you'll see. There's a ton of drivers that have registered. Obviously, by registering is the only way they're going to be able to view their own information. And like I just said, the two reasons for having the registration are to provide that electronic consent or to identify a SAP and get that return to duty process started. All right, let's go to the next one. That one is employers, which is you guys. At least I assume it's you guys. Again, employers do need to register. Again, if you're required to use the clearinghouse, there's no way around registering. You got to register in order to report drug and alcohol violations, to request that specific consent, which happens primarily with pre-employment queries, although there's a couple other scenarios too. If you want to designate a CTPA, which we were just talking about, that'll allow those CTPA to enter your violation or conduct queries on your behalf, which I advocate for as long as it's the right CTPA. And I suppose that's just like anything else, right? Report a negative return to duty. I'm your driver and I have to go through the SAP process. I get done with the SAP process. I give that final SAP report to you as the DER for my company. You send me in for a return to duty test, whether it be alcohol or drug, whichever is required in the case, whatever the SAP requires. When it comes back negative, you as the employer go in and enter that negative return to duty date, and that will flip me from prohibited to not prohibited. After that, then we have the return to the follow-up testing plan, and I see here that it's not a plan apparently, it's a plot. I'll fix that. Anyway. For those of you that have ever been through this process, you know that the follow-up testing plan is a minimum of 6 tests in the first year following the return to duty test. It could go as long as 5 years and as many tests over that 5 years that the SAP requires. Generally, we see a testing on the low end, usually 6 in a year, maybe 8 in a year, maybe it might go a couple of years. But when the last test of the follow-up testing plan is done and comes back negative, you as the employer are going in and entering that date, and it essentially closes that circle. Hopefully that makes sense. Off on the right-hand side here, this is a good note because we're running across a lot of carriers that never updated their company policy, the DOT drug and alcohol policy. There used to be 11 elements required in the clearinghouse or in the policy. The 12th is just some language that's required to be in there for the clearinghouse. If you haven't updated that, get that done. All right, fun with numbers. Here we go. And by current, that's a little misleading because this is as of June, which is, hey, we're the government. That's pretty good. Take a look at the drivers. We're approaching 5 million drivers registered by the end of June this year. Nearly 500,000 employers. And you guys can see, obviously, the numbers for the others. For the drivers and really for the employers, those first couple of years is when you're going to see the biggest numbers, and it'll start tailing off, which makes sense. All right, now the fun stuff. Since January of 2020, so 4 years and a handful of months, there's been 271,000 drug violations reported to the clearinghouse. Most of those are from MROs, right? Those are going to be under this category right here, which is the positive drug test. These two here, refusals and actual knowledge, are employer entered. That's a pretty big number. Alcohol violations a much smaller number, and there's a variety of reasons for that. But as you can see, there was about 6,300 violations of alcohol, of which probably, 2/3 are 0.04 or greater. There's a fair amount of alcohol test refusals too. Lots of violations entered into the clearinghouse in the last 4+ years. This shouldn't surprise anybody. First thing I'll say is on the left, if my math is still right, positive drug tests account for 84% of the total drug violations reported. Obviously, the 16% is refusals and actual knowledge. Marijuana, again, shouldn't surprise anybody, is way ahead of all of the others. The question I usually get right about now during these presentations is, hey, we know that the government is looking at either descheduling or rescheduling marijuana, which is true. And every once in a while over the last year and a half or so, since President Biden made the announcement that they're looking at this, there's been little tidbits that have sort of crept out, right? Oh, they're looking at this, they're looking at doing that. Bottom line is nobody knows for sure what's going to happen. The latest rumor, and it seems like it's more than a rumor, but is that it's going to be descheduled from a controlled substance Schedule 1 to a Schedule 3, which for the purposes of DOT testing probably won't make a difference. The rumblings that I'm hearing is that there's a really good chance that even if it gets descheduled or rescheduled to a 3, it's still going to be part of the DOT test because it's a safety sensitive position. Keep in mind the bulk of what's happening here with the rescheduling is for criminal purposes, not for testing purposes, if that makes any sense. They want to take these criminal prosecutions and throw them out for possession or use or things like that. That's more of what this is about. I know the trucking industry got pretty happy when they saw that it was going to be taken off, but we have to wait and see. I personally would be surprised if marijuana came off the 5-panel test. All right, let's keep going. This one's an interesting one. And if you take a look what they're really saying here, I'll use a little pointer if you can see it. There's been, again, in the last roughly 4 years, a little over 4 years, 235 unique drivers that have had at least one violation entered into the clearinghouse. Of that, there's still 163,000 that are in prohibited status, which seems crazy to me, because what it really means then is there's only 72,000, or roughly, what, a third ballpark? A third of these that have gone through the return to duty process. There's a number of reasons for this. One reason is, hey, I'm a CDL driver. I like my weed. I'm not going to go through return to duty. I'm just going to go work somewhere else, right? That would explain some of these, of the 163,000. Another thing that's going on, and we're running across it because I have a series of state and federal investigators that do compliance reviews with trucking companies and motor coach companies and school bus companies all the time. What we're seeing is some of these prohibited drivers, they're shopping around. And what they're looking for is somebody, an employee that's not running the clearinghouse, if that makes any sense. If you're not running the clearinghouse, and I'm not telling you that I'm prohibited in the clearinghouse, I now have a job. I don't know what the numbers are, but I think there's a chunk of this that fit that description. And this is a really good point to say this is why you need to run the clearinghouse, because these drivers are out there and you don't want them operating your vehicles for a variety of reasons. Potential litigation somewhere down the road could be one of them. Regulatory noncompliance is only a small part of the reason you don't want these people operating your vehicles. If you haven't been doing your clearinghouse queries, please do them, because it's really a cover your butt type of situation too. All right, I think that might have been it for my stats. Did we have any questions at all, Holly, on anything yet?
I do, actually. There is a question. It says, as a TPA, how does the return to duty process work with an owner operator?
Oh boy, how much time you guys got? The owner operator questions make me shudder a little bit because it's the exception to every rule, right? An owner operator is required when they're going through the return to duty process to have a CTPA, and it's really a couple of different things. One is FMCSA is now allowing, I have a hard time saying this because I don't love it, but they're now allowing CTPAs or individual drivers to register in the clearinghouse as an owner operator, assign a CTPA, and have them enter the return to duty negative. I don't think that's what this question was, but I thought I'd mention that. The rest of it is all with the follow-up testing plan. The follow-up testing plan in an owner operator situation is run by the CTPA. They need to follow the SAP report that's supposed to be delivered directly to them. Keep in mind, the follow-up testing plan should never be seen by a driver. The CTPA for an owner operator should be sending in that driver following the SAP follow-up testing plan. Not sure I answered what they were looking for. Let me know. Is there any more?
Yeah. How do you add a new DER to an existing account?
I don't work for the clearinghouse, but I've been around them long enough to know some of these, right? I'll do my best on this. If you have a new DER and your previous DER is still working there, we see this a lot where they just move on, they do it different, but they're still within the same organization. Then it's really easy. All you have to do is have the previous DER go into their account and send an assistant invite to the new DER. Once they've registered as the assistant, the old one can actually elevate them to the administrator of the account, if that makes any sense. It's a two-step deal, but that only works if the previous administrator is still accessible, right? If they still have access to the clearinghouse, you can reach them. If they're within the same organization, it's usually pretty easy. If they've left and you can still get a hold of them and they have access, you could probably do the same thing. But sometimes they're just gone. And if they're gone, you have to reach out to the clearinghouse and explain, this is the person that was our administrator. They are now gone. This is the person that we want to be the administrator. And then they will provide instructions.
Perfect.
It's just clearinghouse.dot.gov is their address or their email address.
Great. Can you talk about actual knowledge and what actual knowledge is?
Woo, here's another good one. You guys are asking great questions. Let me show you guys something. Since I have the screen here, I'm going to show you exactly what it means. Within our regulations, there's a definition in Part 382, 107, and just bear with me, my computer's a little sluggish here. And I'm going to show you what it means. And because there's still, even after you read the definition, it's a little bit confusing sometimes. All right, I'm going to grab this. And if you go to 382-107, I don't know if you guys can read this or not, but the actual knowledge is right here. And I'll read it for you, and I think that'll answer part of it, if not most of it. Actual knowledge for the purpose of subpart B of this part means actual knowledge by an employer that a driver has used alcohol or controlled substance based on a series of things, right? I wish they almost had this bulleted because I think it would make more sense that way. But really what they're saying is based on either the employer's direct observation of the employee, in other words, they actually saw them smoke weed, do something Schedule 1, right? Second thing is information provided by the driver's previous employer, which for the most part is clearinghouse, although with you guys, you might have some rail previous employer situation that you're learning about it. Here's the one that's the big deal, the one we see the most of. A traffic citation for driving a CMV while under the influence of alcohol or controlled substance. Now, keep in mind it says a citation. There has to be a charging document, and it has to be in a commercial motor vehicle. If I have a CDL driver working for me that got a DUI, driving around in his personal vehicle, that is not actual knowledge. He is not prohibited. Now, he probably is going to lose his CDL, but if he gets convicted. But that's a whole nother thing. That's another avenue. But as far as actual knowledge, it has to be an actual charging document citation, and it has to be in a commercial motor vehicle. And by commercial motor vehicle, we're talking about a CDL required vehicle. And then I think there's one more on here. There it is. It says, or an employee's admission of alcohol controlled substance use. And that's basically if they say, I do meth, right, to the employer. Somebody have something?
I was just going to ask, just to verify, driving under the influence in a CMV, is that a conviction or just that citation or charge?
It's a citation. If you have a driver that's out there, and usually the way you find out about it is because there's an inspection, right? And the inspection lists it. Because let's face it, if I'm a driver driving a CMV and I get a DUI and there's no inspection, you think I'm telling you? Maybe not. However, once an inspection is written up, then the employer has access to it through their portal. What you'll see as an employer a lot of times is you'll see on an inspection that my driver got cited for DUI in a CMV. The moment I see that, again, simply cited. You need to make sure there's a charging document. But once I see that, I have to go into the clearinghouse, and by I mean you guys, the employer, have to go into the clearinghouse and enter that actual knowledge violation. The driver then needs to go through the return to duty process, just like you would for a positive DOT or refusal.
Okay.
A few years ago, very few people knew about actual knowledge, even though this has always been there. This has been there for 30 years. Okay, we good on that?
I think we're good.
All right. Cool. All right. Should we go with the final rule, or you got more questions there?
I think I got questions pertaining to the final rule. You can go ahead.
All right. There was a Federal Register. I told you the background here, right? The original 2012, actually 2016 Federal Register was a little vague in what state driver's license agencies needed to do when it came to a prohibited driver and the CDL. Federal Register in 2021 said, okay, here it is. Here's specifically what you need to do. Now, granted, there was some flexibility there. States all have different computer systems. You'd be shocked. Some of them are legacy systems that are older than me, and I'm old. Effective date is November 8th of 2021. But the compliance date, which is the bolded one there, was 3 years later, 2024. This gave the states 3 years to get their computer systems and their processes ready to roll. From what we can tell, a lot of these rules get pushed back. I don't think this one's getting pushed back anymore. I think November 18th, 2024, you're going to see this implemented. And what it does is it establishes requirements for the SDLAs, the state driver's license agencies, to essentially disqualify. There's a lot of words you can use here. Downgrade, disqualify, use whatever word you want. Basically, what's going to happen here is that driver is going to be stripped of their commercial driving privileges. They'll still have their base license, but they won't be able to operate CDL vehicles, A, B, or C, none of them. That being said, if you're really looking for some fun reading on a Friday night, this is where you find the final rule. Beginning on our magic date of, 4 months from now, roughly, states are going to be required to do the following. There's going to be a mandatory downgrade, which is going to remove the CDL or CLP privileges when that driver's clearinghouse status changes to prohibited. The CDL CLP privileges will be reinstated if the driver's clearinghouse status changes to not prohibited, which makes sense, right? Non-issuance, so that's for the existing CDL CLP holders. For the newer ones, or the ones that are, if you look down here, This is what they're talking about for licenses. Basically, any transaction would be issuing, duplicates, renewing, transferring, adding or removing endorsements, for example. All of these are considered commercial licensing transactions. Once the driver goes in for one of those, are all going to be denied because the states are going to be required to look at the clearinghouse for any of these situations, and they're going to be denied. As a matter of fact, at that point, they're probably going to be not even have their CDL anyway. Let's go push in a poll. I think that was. I think that was.
So the couple questions that have come up in regards to this is, how does this apply to California? Is one of them.
Same as the other states. Federal law has always been a trump state law, and in this case, states cannot. And I guess I know California has a whole bunch of laws, a whole bunch of different ways of looking at things, but the state law cannot trump federal. There's literally nothing different for a California licensed person than there is for Ohio, Minnesota, Florida, whatever.
How about this question? How do I get a driver corrected that is still showing as prohibited in the clearinghouse?
That one we need more details on, because there's a variety of reasons that they could still be showing in the clearinghouse. I'm going to go with an assumption here, because I'd say 6 out of every 10, I hear this question a lot, 6 out of every 10 is this scenario. And if it's not the scenario, have the person just update their question a little bit. But if the driver already went through to the SAP and went through the return to duty process, so they're done, right? If they haven't done their return to duty test, then the employer needs to send them in for the return to duty test to get the negative, and then the employer goes in and changes that, right? That's the process working the way it's supposed to. However, sometimes things don't line up quite that simple. There might be a scenario where you have the piece of paper, the negative, in your hand, showing that it was a return to duty, observed test, just like it's supposed to be, but the clearinghouse is still showing that it is, that the driver is prohibited. You need to go into the clearinghouse and figure out where the system went wrong, because it's possible that the SAP didn't enter the information, or they put a date in there that wasn't right, because within the clearinghouse, everything has to be sequential. It has to be the driver hooked up with the SAP on this date. The next date has to be when they did their initial assessment. The next date has to be when they were eligible for the return to duty test. The next date has to be the employer entering the return to duty test. It has to be done in order. It has to be done sequential. We've seen where a SAP either doesn't put it in timely, the return to duty test is entered before the SAP put their information in there, and the system says you can't put it in there yet because they're not eligible yet. Again, there's a bunch of scenarios, and what I would do is, my email is right here. If you have one of those situations where you're just looking at the paperwork saying, hey, dude, my driver has a negative return to duty test here, but he's still showing as prohibited, email me. There's usually a pretty simple answer on these.
I have a couple other questions that came up a little outside of the clearinghouse. Can we ask those questions?
Are they baseball questions?
Maybe. Depends what our... Here's a question in regards to driver qualification files. Let's see here, driver qualification requirements for diesel technicians who have a CDL to road test trucks.
Yep, if you're hitting a public road at any point, right, and diesel mechanics do, right, because they have to do the road test, you're qualified just like every other driver. The driver file needs to look exactly like the guy that's driving from Texas to New York. There's nothing different there. Now, if you have a mechanic who never leaves the yard, right, and the yard is, if you have a big yard and they can do their road testing there, which I find hard to believe, but maybe, if they never hit a public road, then they're not required to have a CDL, which means they're not required to have drug and alcohol testing, which means they're not required to have a DK, none of it. You don't need any of it. But that is rare, to say the least. Usually the only way these mechanics are going to know for sure what they did actually worked is by hitting a real road and getting the highway. I was going to say that not only, and it might be what you were about to ask, not only do they need a driver file, but they need to be in the drug and alcohol pool as well. If they're hitting a public road in a CDL required vehicle, they're subject to Part 383, which means they're subject to Part 382, which is CDL and drug and alcohol. Was that the question you were going to ask or no?
Nope, it wasn't, but you were close.
All right.
The question is about it's back to that multi-mode, and a lot of rail and transit employers may hire someone in transit, and then maybe a year down the road, that person works to obtain their CDL. The person goes in and does the medical exam, and along with that, tries to do the drug test. But when we do the drug test, we need to have our CDL, but that CDL isn't on there because we don't have a CDL yet. Can you walk through that?
Yeah, so we ran across this with school district, not school districts, although some of them too, school bus contractors in particular. They will offer a bonus to come work for them, and part of, in addition to the bonus, they're going to have you run through all the training to get your CDL. What historically was happening was these CDL, or not CDL companies, the contractors would hire me, right? I just had a Class D license, but they're giving me this nice little bonus. They're going to send me the training. They would do a DOT drug test before I even started the process. I'm not subject to Part 382 because I don't have a CDL and I cannot operate CDL vehicles. I'm not subject to that test. That test cannot be a DOT test. You can do a non-DOT test. That's fine. But you can't do a DOT test, including a pre-employment test, until I either have a CDL or a CLP. What the school districts here in Minnesota and the school bus contractors are doing now, because we've beat on them about this, is they'll do a non-CDL test, or not a non-DOT test. And really the reason for that is they don't want to put a lot of time and money into a driver if they're going to pop positive, right? I completely get that. The problem is they can't do the DOT test yet. So they'll do a non-CDL before they start the training process. Then they'll do all the training process, and once that driver goes in and passes the road test and now actually has a CLP, they immediately go in for the pre-employment DOT test. And once they have that back, which is usually a day or two, then they're good to hit the road. They're also putting them into the DOT random pool at that time too.
What if they've already? Sorry.
I was going to say, here's the downside, something that will make you think about this. If you send me in before I have a CDL or a CLP on a DOT test and I'm positive, that's going to cause all kinds of problems because now it's being entered potentially into the clearinghouse. I can't get a job anymore because you put me in for a test that I'm not even subject to. I've seen where the individual that's prohibited in the clearinghouse when they shouldn't even have been subject to it actually sues the company that put him in there. Again, I hate to say this, but a lot of times litigation in real life is more of a slap in the face than the regulations are.
If we are a multimodal carriers and perhaps had a different authority federal pre-employment test prior, do we still do a federal FMCSA pre-employment after that road test?
You wouldn't have to, and this is something we were talking about yesterday, and I want to throw this out there because most people don't know this, because this came as a result of a lawsuit that FMCSA lost several years ago, probably 2-3 years ago. Might have been longer now. But for some reason, this information never really made it to the mainstream. And what it really is, I'll back you up. It was actually out of the Minnesota division. It's our case that got thrown out. I'm so proud. We had a carrier that hired a driver back in January. They ran him through the pre-employment test, but they'd never used the driver as a driver. They were employed. They were working the dock. They were dispatching. I don't know what they were doing, but they were still employed there. 6 months later, they started driving. And our investigator said, since more than 30 days have passed, since you had that pre-employment, you need to have another pre-employment because you never drove. And that was based off of a regulation that really had nothing to do with pre-employments, but it has become common knowledge. Unfortunately, it's not correct common knowledge. Our lawyers came back and said, we've discussed this all the way up to headquarters, and we had a lawsuit basically that particular case was thrown out. And it had to do with the way our regulations were written. I won't bore you with it, but the way our regulations were written is that the definition has to do with the definition of an employer. End of the day, here's what you got to remember. As long as you have done a DOT test on an employee, and it was valid, and they were subject to it at the time, as long as they're still your employee, they never have to do another pre-employment test. That's new. People didn't know that. And there is an update to the regulations that's being written now by the Drug and Alcohol Program for FMCSA that's going to address that. And I think it'll correct it. I can't tell you exactly what it's going to say, but I think it's going to put a time limit on it and say, hey, if you're not in a pool, in a random pool, for more than 30, 60, 90 days, whatever number they come up with, you need to do another pre-employment. But that language was never in our regulation. It will be in the future, but it isn't now. Again, if you have an employee who was tested appropriately under any of the DOT modes, and they were safety sensitive to that mode at the time, if they were your employee the whole time, you don't have to do another pre-employment test. I know I rambled there, but did that make sense?
I think it did, and I think you're right, that it is something that I think for so long everyone has been told if they're out of a pool for any reason, you need to do a new pre-employment test. If they're an employee, that's different, right? That wouldn't be correct.
Yeah, absolutely. Yep.
Mm-hmm. I think that's great. That's great. A couple more came in. There's a question that came in, is that the same for a railroad? If I hire someone as a dispatcher, then they become a transportation employee, do they need another test? If they're a FRA regulated dispatcher and go to a transportation test, maybe they become a engineer, they would not need a federal test because they've already have that under the regulation. If I didn't answer that question, oh, sorry, for FRA, sorry.
Yeah, I'm FMCSA, so I can't answer that one.
Yeah, so on the FRA side, you would not need.
Yeah, I can answer for it is if that second job was FMCSA, which it sounds like an. If it's two different sort of classifications within one of the other modes, I can't answer because that's all in their regulations.
Exactly. Another one, is there a time frame for returning the employees for the pre-employment testing? I'm not sure what returning the employees.
We may have just covered that one. Unless they can. Yeah, I don't see how well. Yeah, I think that was answered. Yeah.
Oh, if they quit and get rehired, let's just say if someone quits. Yeah.
Yep, that's where the magic 30 days came from. It is in our regulations that if you're outside your employment for more than 30 days, then you need to have a pre-employment test. That's actually where this whole 30-day thing came from. It just blossomed into everything. Bottom line, 30 days. Yeah. If they're not your employees. People used to think it was if they weren't in a pool for 30 days or more. That's not the case. It's if they were not under your control as an employer for more than 30 days.
Mm-hmm. If someone resigns for 5 days and comes back to work, you do not need to do it because you haven't hit that 30-day window. Is that right?
Correct.
Okay. Great. And hopefully that answered that question. Here's another one, clarifying that if an employee has a pre-employment test and remains an employee and in their pool, if he sits out of the pool for 60 days due to medical reasons, does he need to retest to go back into the pool?
No.
No. Because
as long as they're exactly. And again, I know it's different, and I stand in front of rooms and I get a lot of jaws dropping. But again, this was based on a legal case that we lost. And because of that legal case that we lost, the regulations being rewritten. Currently, this is our guidance. It'll change somewhere down the line.
Another thing that maybe more of a comment, maybe looking for your advice here. We've tried to contact the clearinghouse and we're on hold for long periods of time. and get no
Yep.
answers.
Yep.
What do we do?
Dale, there's only two ways to get a hold of the clearinghouse, and I actually had this happen yesterday. I was dealing with a Minnesota, is a motor coach company that I deal with all the time, and they said, "Hey, I need this done," and I said, that particular situation, it was a portal issue. The only people that can change that is that 800 number. And I said, if you go, I've been told that if you go call the 800 number and hit, I thought it was option 5. I might have been wrong, but whatever it was. I've heard that it's actually very quick. It goes directly to the clearinghouse people. He called me back about 5 minutes later and said, they told me the wait was 152 minutes. No, I don't have anything on that. There's only two ways really to reach out to the clearinghouse. One is that way, which is the phone number, the 800-832-5660, I think is what it is. And then hit the option for clearinghouse. There used to be a different number until about 2 months ago. That number no longer exists, which is frustrating. The other is just sending an email to clearinghouse@dot.gov. Beyond those two things, no, I don't have a back door for you, if that's what you're asking.
I think that's what's being asked. Yeah.
I think so too, yeah. And on that note, the clearinghouse is so incredibly understaffed, just crazy understaffed. They're in the process of hiring, crossing our fingers that it helps everything all along, including these inquiries.
If we go back to that slide with the prohibited drivers, do you know, are most of those owner operators, or do you know if they're under employers? Is there a way to know that?
Say that again, I didn't catch that.
The list of prohibited drivers with the CDL that haven't made it through the SAP process.
Yeah.
Do you know if those are owner operators or if they work for an employer?
We don't know, because the prohibitions themselves are based off a chain of custody, which doesn't say any of that. Okay. It doesn't say what they are. It just gives a CDL number. You know what I mean?
Mm-hmm. Yep. And you talked about if a driver's license status or something in the clearinghouse changes, an employer is notified of the changes in the clearinghouse. How is that employer notified?
My understanding is within the clear. I asked this a while back about, hey, do you get an email? And at the time, the answer was no. I don't know if they've updated that or not, but I'm going to go with the old answer. But if you log into your clearinghouse account, there will be a prompt in the upper right that will say like notification, or I'm trying to remember what the wording is, but there'll be something there that'll prompt you to look at it. And for all I know, quite honestly, again, I'm not part of the clearinghouse. They may actually have notifications being sent out now. I can look into that one. That would obviously be ideal.
It's probably a good practice to go in and check your clearinghouse very often.
Yeah, and I'm going to check into that, because I'm thinking the same thing you guys are right now. Is if I'm only going into the clearinghouse once a year, what good is that notification going to do me if I don't see it? I will check if there is something else, whether it be an email, or it's got to be an email, right? There's no other way for that prompt to happen. I'll check into that.
And can you give us that clearinghouse phone number again?
There it is, 800-832-5660. My understanding is if you come in and use this clearinghouse help, like web, I forget what they call this, like the web, whatever you call it, that it's quicker. That's just what I've heard, that instead of calling this number or sending an email to clearinghouse@dot.gov, if you fill this thing out, my understanding is the turnaround is quicker.
That's good information. That's great. And that's right on the FMCSA site?
Yep, it's right on the clearinghouse site. You just go to contact.
Great. And I think the FMCSA has done a really great job of having this website for all of the information in regards to the clearinghouse. Lots of questions and answers.
For those of you that haven't fished around in here, I'm just going to, since I have you as a captive audience, if you just go to where it says Learn in the Learning Center, if you go to Employer Resources, this is awesome. Everything, pretty much everything you would need to do has a PDF for it, right? How do I designate a CTPA? how do I do my queries? How do I purchase a query plan? Just as an example, every one of them is a PDF screen by screen. As much as I get frustrated with the amount of time it takes for them to respond to anything, because it's frustrating for them too, there's a lot in this learning center. And if you have drivers that have questions, just go over here to the drivers. Owner operators, same deal, right here.
That's great.
So that's my little clearinghouse. The clearinghouse learning center is really good.
Wonderful. Do we have other questions before we wrap up today's webinar? I know this has been great to have all of this information. Looks like they're quiet now.
Okay.
I still think I look at this and I see all of these prohibited drivers, and definitely just very interesting, very interesting.
Yeah, again, a lot of my FMCSA career has been drug and alcohol related stuff, and you would not believe what we see. Everybody says that wouldn't happen to my drivers. Yes, it would.
Yes, it would. Yes, it would. Great. If you don't mind, I'll take over and become the presenter again.
Of course.
All right. And I'll share my screen here. Let's just make sure I'm sharing the right screen. All right.
Am I free to leave?
Well, no, you can't leave. We like you.
Okay, I'll stick around.
No, again, we want to thank Charles for being here, or Chuck being here for the FMCSA. And I think his information was really great outside of the clearinghouse even. It's really great to get that feedback from you, from the FMCSA directly. Oh, I do have a question, it looks like. Oh, can I ask you another question?
Yeah, sure.
Okay. I do receive emails on drivers. I have queried when something has changed in the driver's profile. It advises I may need to acquire another signed authorization form to get that updated info. Not a question, more of a comment. That's a great comment.
That's good. That saved me some time. I learned more than you guys did.
See, there we go. We've got great people on the call. Wonderful. Thank you for that feedback. We appreciate it. And again, we look forward to having you on the next webinar. And thank you again, Chuck, for your time. And thank you to everyone for joining. Have a great day.